So Mr. S.K. Murthy, today's speaker, let us welcome him. He is the Director of IP in the Intel India organization. He is a qualified Indian patent agent with an engineering background, that is Masters in Electronics, and a legal degree, diploma or degree in LLB and intellectual property rights. He started his career as a faculty member in the Department of Instrumentation and a design engineer in leading edge semiconductor processors and telecom products. Then currently he is employed with Intel Technologies India Private Limited as their patent counsel for India. With a total of 16 years experience, he has more than 8 years of experience in preparing and prosecuting US and Indian patents, which is a very important aspect in the case of infringement. And he has been very prolific in training engineers and professionals. He has been a speaker at CII DIPP in Bangalore, Institute of Science, and a score of engineering colleges and universities. So over to you, Mr. Murthy.
Ma'am, thank you so much for the kind introduction, and I'm very happy to be here. It feels like I'm going to my good old days when I started my career as a member of the faculty in an engineering school.
Can we see you? Switch on your video.
Sure.
Others also, if you can switch on your video. Hi.
Hi.
Yeah, others, can you switch on your videos if you can? Or else it's fine. Yes, sir.
Yeah, up to them. Thank you so much for the kind introduction. And as you very well know, intellectual property is one area of law which requires a technical background, right? Technical background or science background. Without a technical or a science background, it is very hard to deal with most of the flavors of intellectual property. And I am very sure that you had an opportunity to get introduced to different flavors of intellectual property rights, right? So just to
there's some lag. Is there some connectivity issue?
No, there is a lot of background noise. So if you can kindly mute yourself if somebody is not talking.
Okay, colleagues, can you please mute yourself? I'll write it in the chat box also.
Okay. So intellectual property rights is a very special area of law, right? And that is why it requires interdisciplinary people, more and more interdisciplinary people getting into this field of law. Otherwise, it would not make much sense at all. There is
mute yourself.
There is a lot of background noise. Kindly, I request you to, those of you who are not talking, please mute yourself. And if at all you have a question, you can definitely
yeah, I've written in the chat box also, and I'm announcing also. I've written it in the chat box also. I'm sorry.
Okay. No problem at all. So in one of the earlier sessions, you had an opportunity to listen to a speaker who talked about flavors of intellectual property. What is intellectual property, right? Mm-hmm. So I would like to very quickly brush through the different flavors of intellectual property, because whatever I talk about design rights today, right? It is very important to understand the subtle differences between different flavors of intellectual property. If we don't understand the subtle differences between the flavors of intellectual property, it will be hard to understand why there are so many buckets of intellectual property, so many flavors of intellectual property. Okay, as you may know, patents, right? What does patents protect? Anybody in the audience? What do they protect?
Audience, please.
Design, technology, design, innovation.
Okay, thank you very much for that. Yeah, thank you very much for that. But if you actually look at what patents would protect is inventions, right? Yep, some formula also, but formula as is not patentable. but an application of a formula is patentable, right? Also, when it comes to medicines, pharmacological combinations, pharmacological drugs as a product and as a process is patentable, right? So what I want to drive home is, or what I want you to remember is, patents definitely protect inventions. And if you look at the inventions, they have a functional element. They are very, very strong on function, right? There is some functional element. For example, if you look at video compression, there is a very strong motivation to compress video because um, the function of compressing, the process of compressing gives you certain advantages, and it is purely technical. The process of compression is purely technical. Likewise, just to give you an example in a mechanical field, right? For example, if there are headlights for a vehicle, they have a very functional value, right? Because they have to focus the beam on a particular in a particular angle. It should fall on the road ahead of you at a particular distance. So all these are very, very functional in nature. So whenever you remember or whenever you recall anything about patents, one thing that you cannot miss or one thing that you should necessarily remember is patents would cover functional aspects of an invention, right? There has to be a function. It has to be associated with a particular way of doing things, right? And as you know, the criteria for patentability, anybody on the criteria for patentability? When is an invention patentable? An invention is
Novel,
patent.
when it is novel.
Novelty
Yeah.
and
Novelty,
inventiveness is
exactly.
there.
Okay, so for you to very easily remember what is patentable, just remember this abbreviation NUN. N stands for novelty, U stands for utility, and N stands for non-obviousness. This particular terminology is used under US patent law, but the concept remains the same under Indian patent law as well as European patent law. Also, novelty remains the same, N. Utility is usefulness, and non-obviousness translates into inventive step, right? Under Indian patent law, the terminology used is inventive step. So if you think of a bucket, right? Just for you to imagine and visualize, if you think of a bucket and you put everything that is known to the world today, everything that is known to the world today, not just in India, right? Everything that is known to the world today into this bucket, right? And you call this as prior art bucket. Prior art, ART. So prior art means what is already known. So if your invention has to be patentable, your invention has to be new as compared to something already inside the bucket. So once it becomes new, it falls outside the bucket. So can I take something which is already inside this bucket or which is already known to the world and make some minor modifications, minor cosmetic modifications to make it new so that it falls outside the bucket, and can I get a patent on it? Probably not, because the wisdom of the legislature is this: once it falls outside the bucket, a very minor cosmetic change is not sufficient to get you a patent. So it has to be at a particular distance from the bucket, right? This delta, right? This delta is a measure of inventive step, right? It has to be outside the bucket to make it novel, and it also has to be at a particular distance from the bucket to establish the inventive step. And why I am revisiting the criteria for patentability is because other flavors of intellectual property also rely mostly on criteria like that of patents, right? So for a patent, it should be novel, it should have use, it should be non-obvious. In Indian parlance, it should be new, it should be capable of industrial application. Once I say capable of industrial application, it translates into usefulness. And when I say inventive step, it translates into non-obviousness invention. So for a patent, for an invention to be patentable, you need to have the patent office will look at your invention, which is a written document submitted by the inventor, and it establishes whether your invention is NUN. If these criteria are satisfied, then only a patent will be granted. Okay. So if a patent is granted, what is it that you get? What rights do you get? Patent is a legal right. Okay. So once you get a patent, you get a right to stop others. This is the operative word. Please focus on this word. It is a right to stop others from making, using, selling, offering to sell, and import the patented invention. So you get 5 rights. It's a bundle of rights. So these 5 things is what you can do. Meaning, if somebody makes or uses, right, or imports or use these 5 things, right? So if anybody uses your patent, if anybody practices your patent without getting a permission from you, a written permission from you, then you can go and stop them. Okay, so these are the rights invested, or these are the rights vested in a patent. Likewise, if you look at other flavors of intellectual property, what are the other flavors of intellectual property that you know of? Any examples?
Copyright, industrial design.
Copyrights, industrial designs. Okay, great. Anything else?
GI.
Trademarks.
Trademarks, fantastic. Then, is trade secret a flavor of intellectual property? Is a form of intellectual property?
Yes.
Are trade secrets a form of intellectual property?
Yes.
Yeah. So if you look at different flavors of intellectual property, other than patents, we have copyrights.
Okay, please switch off your mic. That is really causing a disturbance to the speaker and others also. Kindly cooperate. Okay, that's fine. Thank you.
Thank you very much. So if you look at different flavors of intellectual property, we have copyrights, we have industrial designs or designs. We also have trademarks, trade secrets, geographical indication, Semiconductor Layout Act, all those things, different flavors of intellectual property. So once the flavor of intellectual property, or once we have a different flavor of intellectual property, what gets protected under that flavor needs to be different. The characteristic needs to be different, right? If the characteristic is not different, then it could be protected under one common bucket. But this umbrella or a bucket has different flavors. So if you look at no, at this point in time, I don't have any foils. So I'm speaking through. Thank you so much for that question. Okay, lyrics of a song can be protected by copyrights. Yeah, fantastic. So copyright protection is granted to literary, dramatic, artistic works and computer programs if it is affixed to a medium, right? If you just have lyrics in your head, there is no protection provided for such lyrics that is sitting in your head, right? This has to be reduced into a physical form. You need to write it on a piece of paper, or you need to store it on a medium, electronic medium. So it has to be affixed on a medium. For getting copyright protection, something that falls into these categories need to be affixed on the medium. So when it comes to copyrights, okay, when it comes to copyrights, right? One of the things that need to be observed are the criteria for protecting copyrights is it has to be an original work, right? It has to be an original work, and criteria can be easily found out. But one thing that I would like you to focus on is, if you look at patents, it is in the domain of ideas, concepts, which is supported by implementation details, right? Let us say if you were the first person to invent how to measure time digitally, right? Then that is a concept, and when you are preparing your patent application and submitting to the patent office, you need to provide all the details. You need to write down all the details on how do you implement this digital time measurement equipment or device, and then submit it to the patent office, right? Likewise, when it comes to copyrights, your work has to be original, and also the copyright material falls into the domain of implementation details. So copyrights do not protect ideas per se. It is always the implementation of the idea which is original and novel that gets copyright protection. Do you see the difference? Do you see the difference? Patents are the protection that is provided under patents are much deeper and much broader because it is at the level of the concept. It is the essence of your invention, right? That gets protected. If you abstract it to a level where it becomes an idea, so your claim number one or your claim in a patent application will be the idea, protection for the idea supported by implementation details. Whereas in copyrights, it is on the other end of the spectrum. There is no idea. Let us say there is a copyrighted work, then if you can draw a line between idea and the implementation of the idea, copyrights protect only the implementation of the idea. Okay, so copyrights do not protect ideas. Therefore, always there is a dichotomy of idea and implementation, right? You need to divide it. You need to draw a line where the idea ends and the implementation starts, and the implementation is provided the copyright protection. So one thing to remember is it has to be new and it has to be affixed on a medium. That is copyrights. So if I write a song on a piece of paper, and as long as the lyrics of the song are, if the lyrics of the song is novel and original, you get a copyright, right? Even if you scribble it on a piece of paper, you get a copyright protection for that. Okay. Is it clear?
Yes.
Okay, great. Then what is the subject matter of a design? Guys, if somebody is not talking, please go on mute. Thank you. So what is the subject matter of a design then? If you look at industrial design that is eligible for protection under patent law, right? I mean under Designs Act, what is protectable is something which is merely appealable to your eyes, something which is designing a car or bike. Okay, designing a car or bike can have functional components also, right? For example, if the front portion of the car is aerodynamic design, it may be very, very appealing to the eyes, but it also has a functional component, right? So when it comes to designs, the line that you need to draw is where is the function and where is the aesthetic value, right? So what qualifies for a design is something which has an aesthetic value. So that becomes the subject matter of a design protection. Okay. Now, anything that has functionality, anything that is associated with functionality is a subject matter of patents, and it is not a subject matter of design. So that you need to bear in mind always when it comes to designs. Excuse me. There is some background noise. Could you please go on mute?
Okay, colleagues, can you please mute yourself? Is that okay, Dr. Murthy?
Yeah, now it's better, ma'am. Thank you so much. So when it comes to designs, right, you need to draw a line between idea or functionality and the aesthetic value, and whatever remains in the domain of aesthetic value is a subject matter of design. Now, the criteria for such an article, I'm specifically using article or a product, right? Because if you look at copyrights, it had to be fixed on a medium. Likewise, in case of a design, it has to be fixed to a product, right? Let us see, this is a mouse, right? If there is any design that you have come up with, if there is any design innovation, it has to be affixed or it has to be fixed to this product. If it is not fixed to this product, then it is not eligible for design protection. It is not eligible for design protection. For example, let us say you draw or you come up with a fantastic schematic for a mouse, a fantastic design, and you put it on a paper, right? You draw it on a paper, perfect to the scale, everything. Would that paper having a novel drawings of a design, can it be protected under designs? Can it be protected under Design Act? No, right?
I guess it can be copyrighted, but not.
Yes, exactly. It can be copyrighted, right? Because it is affixed on a medium, but it is not affixed on a product. It is not fixed on a product. It is fixed on a paper, or it is fixed on a medium, wherein there are drawings of a mouse and a fantastic design of a mouse. It is on a paper. So such things are eligible for copyright protection. But once you take this drawings and build a product, then that product, as long as it is appealing to the eyes and does not have a functional value, functional aspect, I'm talking about that particular design, right? Design component. If it has only aesthetic value and no functional value, then such things, as long as it is new and original, can be protected under Design Act. Is it clear now? Can you, is the difference between patents, copyrights, and designs clear? What is the subject matter of a patent? What is the subject matter of a copyright? And what is the subject matter of a design? And what is the criteria for?
Yes, yes.
Yeah, okay. Okay, thanks. So this distinction is important because why I am saying this is, thank you. Why I am saying this is, we have often seen this when people talk about patents, when people talk about inventions, they say it is protected by copyrights. And likewise, a subject matter of a copyright, they interchangeably use it for getting a protection under copyrights. It is not a person who is not into IP, right? We have examples of where high courts, right, talk about copyrights and trademarks interchangeably. Where actually, when you see it in practice, when you look at the actual field of intellectual property, copyrights are way apart as compared to probably trademarks, right? The practitioners itself, there are copyright specialists, there are trademark specialists, and a trademark specialist would not even know much about a copyright, for example, right? So these are two different streams within the stream of IP. That's why it is very important to know these differences, because these forms the basis. Once you know these differences, then it is very easy for you to recognize. When you come up with something, it is very easy for you to recognize, oh, okay, here is something that I came up which may qualify as a design. Oh, here is something that I came up which may qualify under copyrights. Oh, here is something that I came up with which may qualify under patents or something under trademarks. So once that basic understanding is clear, it is very easy to identify whatever you come up with, your creative work, the creative work product of your mind or brain. When you have it there and when you know which bucket it falls into or which flavor of IP it is, then you can easily identify and go protect it. Once you go and protect it, then you can, according to the rights that you get, you can easily monetize it. Especially copyrights and designs are easily monetizable, right? My sincere request to you is, please pay attention to this very basic differences between different flavors of intellectual property. So coming back to designs, What we have is, as I said, it should be affixed to a product, or it should be affixed to a material, or not material. It should be affixed to an article. Then it has to be new and original. And what is not protected under designs is if you take two designs, right, and combine them and come up with a third design without adding anything new into it, then a mere combination of two known designs to produce a third design, which is not original, is not protected under Design Act, right? And it has to be distinguishable from what is already known, what is already protected. Okay, so once I said distinguishable, if you draw a parallels in patent law, this distinguishable. Okay, I'll do it. Difference between copyright and okay.
I have one more question. When we are fixing the aesthetic value of to a product, if we change the material of the product, definitely the aesthetic value will also change. So why not it is also attached to the material?
I mean, as long as if you look at the law itself, right, it does not go down to the detail of saying a material. Whatever brings an aesthetic value, as long as it is new and original, as long as it can be distinguished from what is already existing, and if it is affixed to a product, then it is eligible design subject matter, and a design can be granted, right? That is what it says. If I know where you are coming from. If you use a better material, the aesthetic value can increase, right? Definitely, yes. Sure. Somebody has repeat in one sentence the difference between copyrights, patents, and trademarks, right? Okay. I'll try to frame it in one sentence. You're asking me to pack so many such huge topics into one sentence, but I'll try my best to do it. Patents protect inventions, which are ideas supported by implementation details. Copyrights support literary, artistic, dramatic works, which is in the domain of implementation only. And trademarks define, or trademarks protect, or trademarks are marks which will develop a mental and emotional relationship between the manufacturer and the user, right? I'll come to trademarks. Hold on for a second. I'll definitely talk about trademarks. I'll spend some time to talk about trademarks, right? So when I was talking about designs, to make it easy for you to understand, let me say I have a cup, right? Okay. Look at this pen stand, okay? Look at this pen stand. All these things, all these chambers have functional value there, right? Now, if I have to hold this, I have to hold it like this, because there is no handle for this. So it is not so comfortable, right? It is not so comfortable. Let me say I put a handle to this, right? I put a handle to this. Does the handle have a functional value? Definitely yes. Handle has a functional value. Is it a subject matter of design or a patent? If assuming that they satisfy the criteria for patent protection or design protection, is the handle functional or aesthetic?
Patent matter.
It's a patentable subject.
But actually the distinction is not that clear all the time.
I'll tell you, and I'll continue with this example and make sure that you get the distinction, right? I'll definitely distinguish it for you. So here is a handle. Let us say you invented this handle for the first time, which makes holding this particular pen stand easily. Then it has a functional value. And once it has a functional value, the subject matter that is, or the legal right that protects this functional value matter is a patent. It is not a design. Now let us say you have this handle, but on this particular handle, right, you draw a pattern which is laced with golden and red and blue and green color, right? There is a beautiful peacock-like color drawn on this handle, right? Does it appeal to your eyes? Definitely,
Yes.
it appeals to your eyes, right? Does it have any functional value? There is no functional value because it is a drawing, it is a color combination, it is a sketch of different forms of lines, patterns of lines drawn on this handle. Handle has a functional value, but the color combination that is drawn, that is affixed to this handle, does not have any functional value, but it appeals to the eyes. Therefore, that particular color combination, the way in which it is drawn, right? It could be pattern of the leaves, it could be pattern of different lines, it could be pattern, it could be different color combination. All those things are protected under, or it is a subject matter of design. Okay, it did not have a functional value. It appealed to your eyes. Since it appealed to your eyes, there is an economic value there. If you walk into a store, a crockery store, and if you look at this particular beautiful mug with that painting, right? Just imagine there is a mug without that painting and there is a mug with that painting done on it. It is natural for you to go and pick up a mug with the painting, right? And you are ready to pay, let us say 20 rupees more for that mug or 10 rupees more for that mug. So that is the economical value that a design would bring, right? Is the distinction between a patent and a design subject matter clear now? Right? So
Yes.
yeah, okay, thank you. If you look at the tail lamps of a Scorpio, let us say, right? Earlier, any vehicle had a tail lamp which was either a square or a round or a oval or whatever it is. Scorpio came up with a tail lamp which ran through the length of the corner, back corners. Have you observed it? Does it have a functional value? I doubt whether, or I don't see a functional heavy product there. I see a design heavy product there, right? So it definitely is visually appealing to me, right? And if you look at the indicators, for example, in Audi, for example, right, are very high-end top-end cars. It is like an LED that, okay, great. Can we ignore? Can we ignore the functionality of an article? Okay, I'll talk about it. So good. Lot of questions coming in. I'll try to answer all of them. In case if I don't answer them at the end of the session, we will dedicate 10 or 15 minutes for question answer session. Please bring them up. I'll try to answer to the best of my knowledge. Okay. So in this example of a mug and a handle and a painting on it, it could be very clearly distinguishable as to what is patentable and what can be protected under design rights. But the life is not that simple. Real life examples are not that simple, right? So I specifically took the example of a Scorpio tail lamp because there is some functional element. That is why I specifically used it may be design heavy rather than functional heavy. That does not mean there is no functionality at all. There is functionality. Now, let us say if we take these real world issues or real world articles, and if we try to divide the functionality and the appeal to the eyes component, right? And what is left is, or what would be left under this bucket on the right side, which is appealable to the eyes, is a subject matter of design. And what will be left and in the left portion, that is functionally heavy, is protectable under patents. Now, when you write this on a paper, or when you use a CAD tool, right? When you use a CAD tool to have all these designs in a CAD tool, that is protected under what? That is protected under are protectable under copyrights. Copyrights.
Oh, copyright, sorry. Yeah.
Okay, so now you're already getting an idea that a particular product can be protected under patents, right? The functional aspects, the innovative aspects, I mean, the inventions can be protected under copyrights. The thing that appeals to the eyes, aesthetic value, which satisfies the criteria for design protection, can be protected by designs. And what is written on the paper or fixed on a medium, like a paper or a memory storage, can be protected under copyright for the same product, right? So a practitioner, an IP practitioner, I'm talking about the IP practitioner, then I'll come to the person who generates, right? Or an inventor. An IP practitioner should be aware that a particular product can be protected by one or more flavors of intellectual property and should have that, what should I say, acumen to identify different portions that can be protected under different aspects of intellectual property. As a creator of intellectual property, you should also be aware that, oh, okay, this falls under design. This is a design innovation. This is a patentable innovation. This is a copyrightable innovation. If you are aware of that, and of course, this FDP, the objective of this FDP is to make us aware of this, right? We may not be IP practitioners. Everybody in this meeting may not be an IP practitioner, but definitely you could be a creator. Once you know this, then you can easily identify and then protect and then commercialize it if possible, right? Why I say if possible is all IPs that are protected are not commercializable, right? All IPs that are protected are not commercializable. Okay. One of the research studies say only 8% of the patents. This is a very optimistic estimation, right? This is a very optimistic estimation. It says only 8% of the patented ideas get into our products. What happens to the remaining 92? Do you think they are waste of money? What is your sense? What is your sense of this 92? Any thoughts? Okay, this 92% of the patents are there for specific reasons, right? One of the specific reason could be I have 100 patents, right? On, let us say, memory technology, out of which 10 patents or 8 patents have gone into my product. But I am dealing with another organization, which is also in the memory business, right? Then if at all we get into a cross-licensing agreement, what cross-licensing means is I license my portfolio to you and you license your portfolio in a particular area to me. Then I have 100 patents and you have 200 patents, right? If you look at the stack, height of your stack of patents is more. I have a lesser stack, so I pay you $20 million, right? So that is one of the value. Even though it has not gone into a product, it can be used for cross licensing. And another value could be coming out of this. Let us say you, right, come and sue me for video codec or video compression technology. You have a patent on video compression technology. You come and sue me, right? I have 20 patents to sue back, right? So if I have 20 patents, I go to you and show you that I have 20 patents which I can use to sue you back. So that can be a very strong point for you to arrive at a negotiation table and settle the matter, because lawsuits, especially IP lawsuits, are extremely resource consuming and costly, extremely costly. At least at this point in time, it has not hit the shores of India in a very big way, but It has definitely been there for a very, very long time in the US and in European countries. And the resources that are consumed in a litigation is extraordinarily high. And no organization would want to go and find itself in the middle of a suit. It is not just resource consuming. If an organization is sued for, if it is in a legal suit, right? It impacts the share value. Coming to your own domain, right? Finance domain, it impacts the share value, right? So there are innumerous impacts of having or getting into a litigation. So most of the companies do avoid litigation, but there are companies which use litigation as a tool, to increase their competitiveness, to bring the competitors, to put the competitors on a back foot, right? For example, if you look at Apple, right? Apple has a larger risk appetite for litigation as compared to many, many other companies, right? So if you just go and do a search, you'll see Apple suing Samsung, right? This is a very, there is a very, very famous case wherein Apple sued Samsung, and in the suit of IP assets, there were several design patents. In India, we call it design rights, but in the US, we call it as utility patents, right? The patents that we talked about all this time are called innovation patents in the US, and the designs that we talked about, design protection that we talked about, is termed as what? Utility patents in the US. So if you go and do a search on Google, you will see lots and lots and lots of cases which involves utility patents as well, right? So in case of Apple versus Samsung, Apple sued Samsung, and there were around 8 patents or so. And out of these 8 patents, at least 3 patents were design patents, right? And these 3 patents later on was invalidated by the US Patent and Trademark Office. But I can give you just an example so that you would have observed this, right? On an iPhone, when you are reading, when you come to the end, if you slide your finger on the content on the page, it bounces back. The page bounces back. Have you observed it? That is known as rubber band effect, and that was given a utility patent in favor of Apple in the US, and that was a subject matter of litigation in the US, right? So design patents or utility patents in the US find value. And coming back to India itself, right? We have known this, these are some of the cases which are already in front of the court, and some of them are already decided. If you have bike riders in your home, or at some point in time, if you used a bike, then you would definitely have used a helmet. And Steelbird is one of the famous brands in helmets, right? And Steelbird has a specific design, right? Specific design of an helmet. And another organization copied this particular design, and they started making money out of this, right? They started selling helmets in the open marketplace, and Steelbird had to go to the court, Delhi High Court, and they sued this organization for infringement of designs. One thing that happened in this particular case is the defendant, right? The company which was copying Steelbird's helmet design did not appear in the court at all, right? So judge passed an ex parte order and awarded, at the request of the plaintiff, that is Steelbird, they awarded 96 lakh rupees or so as a damage, right? So design cases have hit India as well, right? They have been adjudicated in Indian courts as well. And another example is, how many of you have worn Crocs at least at some point in time in your life, right? we have seen, we have owned Crocs or we use Crocs. Crocs is a what should I say, sandals, right? Crocs is a sandals company, footwear company, and they sued Bata, right? They sued Bata, alleging that Bata is using Crocs designs and making products, and it went to the court, and the High Court decided that based on what Bata produced, right? Based on what Bata produced, Crocs, even before getting design rights, even before approaching the design office in India and getting a protection, they had already published it on their website, right? They had already published it on their website. And once the publication is done, even before you go and get a protection, what happens? Which criteria is affected, is impacted hugely? Novelty, right? Remember this bucket example? Whatever is known to the world, let me put it into this bucket. And my invention or my design has to be new and original. That is, it has to be outside this bucket as compared to something which is already inside this bucket, right? What happened when Crocs displayed its Crocs particular sandal design on its website, even before it got design protection? What does it happen? What happens?
The novelty is gone. Probably most of the people might have already seen it, and so.
Exactly. So it is equivalent to taking this novel design and putting it into the prior art bucket. Once it is put into the prior art bucket, once it is a portion of the prior art bucket, there is no more novelty in it. If there is no novelty, then there is no design protection that can be given. But Crocs went and sued Bata, and Bata could collect this evidence and show that even before Crocs could get a design protection, it was already there on their website, which impacted or which destroyed the novelty. And court, after looking at this, it invalidated the design rights of Crocs, right? So the design right that was granted to Crocs was no more valid, right? So there was no infringement at all. One thing with this example, one point that I want to drive home is whenever you come up with something, especially in the academic world, because I was part of the academic world, and even today I am heavily connected with the academic world, right? My relationship with National Law School goes beyond 10 years. In the academic world, of course, things are changing slowly. In the academic world, the first thing that comes to your mind naturally is to write a paper and publish, right? I'm not saying publication or publishing is not valuable. It is definitely valuable. It has its own place. Like patents has its own place, and copyrights has its own place, and designs has its own place. All these things have their own places, right? They are not mutually exclusive. All I'm saying is, if you want or if you come up with a particular IP, intellectual property, the first thing that you need to think about, the first thing that you need to check is, should I go get a right on this? Should I go get protection on this? Then only you can go and publish, right? Especially when it comes to patents and designs, these two things. For patents and designs, you really need to go to the patent office and the design office respectively and disclose your invention supported by implementation details and your design to the patent office and the design office respectively. And they should take this invention and your design through an examination process, and they should grant you a certificate. They should grant you a patent. They should grant you a design right. Okay? Without having a design right, without having a patent right granted from the concerned office, after a due examination process, you really don't have a right in the first place. You really don't have a legal right in the first place. Is it true for copyright and trademark? No. You write a piece of, you write a poem on a piece of paper and put it up on the internet, right? You did not go to copyright office and get a protection. You did not go to copyright office and get a registration certificate, copyright certificate. You did not. Still, in spite of not going to the copyright office and getting a copyright certificate, you still have a copyright. You still have the right. The only burden on you is if somebody infringes and if you, okay, if somebody copies your copyrighted work and if you go and sue them, you have the burden to establish that you were the first to come up with this in the absence of a copyright registration. Of course, there is an option or there is a possibility to go get a copyright registration. When you go get a copyright registration, all you have to do is in the court, you have to produce this registration certificate, copyright registration certificate that serves as a prima facie evidence in the court of law, right? So when it comes to copyrights and trademarks, you really don't have to go to the copyright office and the trademark office respectively and get a protection or get a certificate. But in case of patents and designs, it is mandatory for you to go get a certificate. And patent office and the design office will take your invention and take your design. It will apply the examination criteria and then it will grant you either a patent or a design if it satisfies the criteria, right? So this distinction should be very clear in your mind. Okay. So,
Dr. Murthy, can I ask one question?
Yes, please.
So in, say, for example, design class, many a times I give some sort of assignment where they tend to solve some problem, including products with the functional as well as aesthetic value. And many a times, there is a lot of novelty in it. And yeah, I don't know how to kind of make sure whether the student, many a times the students are also hesitant in submitting their designs or, say, for example, presenting it in the front of other students, feeling like people may copy or something like that. So how to deal with such kind of things?
Okay, great question. Great question. I would say even within organizations which are heavy on innovation, right? Inventions, patents, IP protection is bloodline for several companies like Intel, right? Even within this organization, which is so savvy about innovation and IP protection, right? Employees come and ask the same question. Oh, if I come and talk in a group and if somebody copies it, what happens, right? So first level of protection is this. Let us say I am your student. I come up with a design and I think that, right, I have made some analysis and I have differentiated or I have drawn a line between the functional aspects and the pure aesthetic aspects. Now I want to go get a design protection for these aesthetic aspects. First thing that you need to do is, or first thing I need to do, because I am a student in this example, I need to do is put this on an email, create a written record, right? If they are sending it to you, fantastic. And if they want to copy few others, like the dean, very good, copy it. And also in the subject line, right? Or at the beginning of the email, put it as confidential information. And right, once you put that header and once you document it in an email, after that, if you even go and talk about, but please be careful about this design. Once you go and talk about it in public, right, within four walls of your organization, it is okay. But if you go and talk about it in public, in a conference, it is equivalent to putting it into the prior art bucket. So even before that, you can go and register the design. Design registration is definitely very, very, very affordable. And if I may suggest, the organization should definitely set up some fund, right, which will enable the faculty and the students to go get design registrations, right? You have seen this, right? Though I don't subscribe to this, but there are certain institutions in India itself which say that, okay, in 2019, we got 30 patents granted. If you look at the quality of the patents, right, and if it goes through an invalidation proceeding, probably out of 30, 1 may survive, 29 may fail, but still they got 30 patents and they published it on their website saying that we got 30 patents, which is creating a goodwill for your organization. So you may consider doing that. And then once you do that, the ownership issues come into play. Who should be the owner? Who should own it? Then you need to talk to somebody, a professional, right? Engage an IP professional and have an IP policy for your organization, which defines, which also includes the ownership rights. And if it is commercialized and if you get licensing revenues, how would it be distributed between your organization and the inventors, right? And the creators. All these things has to be put in place so that you have a system, you have a process to support all your activities, right? So that's a fantastic question. And today, several organizations lack a IP policy for their organization. They don't have a structure put in place, and randomly IP is generated, and then they go grapple with ownership issues. Then the creator says, or the innovator says, it belongs to me because I invented. The organization says, you used my resources, so it belongs to me. You don't have to get into a scuffle. Scuffle is not the right word. You don't have to get into an argument about it because you already have an IP policy which defines what can be done, right? Okay, I have few questions here. Trademarks for the branding, patents for invention, copyright for intellectual creation, trademarks for branding, patent for invention. If you explain how to file design, okay, I'll do it. Copyright is for literary, artistic, dramatic, software, computer programs per se, right? Which is heavy on implementation. Let us say, I know I have been talking theory, idea and implementation. Let me give you an example. Okay, you may have read, of course, all of you would have read or heard to Mahabharata in one way or the other at some point in time or the other, right? So there are two authors who have authored Mahabharata, right? The central story is the central idea of Mahabharata is the same, right? The central idea of Mahabharata is the same. Did anybody get a patent on Mahabharata? Probably not. They cannot get a patent on the central concept of Mahabharata, for sure. But can these two different authors who have expressed certain sequences, certain characters, certain situations, certain conversations in their own imagination, which is novel, which is new and original, can they get copyright for that? Both the authors can definitely get copyright, right? Do you see the difference? I'll give you one more example. Let us say everybody is used to use this e-commerce apps, right? For developing the e-commerce app, right? Somebody might have used Java as a coding language. Okay, there is an algorithm, and somebody has used Java to reduce this algorithm into a code. Somebody has used the same algorithm, meaning the same concept, and they have reduced it into practice using C++, right? These two implementers who have used Java and C++ for coding they will definitely not get a copy. I mean, they will definitely not get a patent because patent is in the algorithm, right? But implementation in Java, implementation in C++, they may be copyrightable as long as they are new and original. Okay, so it is the expression of the idea that is protectable. It is not the intellect. It is not just the intellectual creation, right? Definitely, it has to be an intellectual creation. Professor Swine, I'm answering your question. Copyright for intellectual creation, right? Definitely, all intellectual property rights. At the heart of all intellectual property rights is the intellectual creation, but the form in which it comes, the form in which it presents itself, is what distinguishes it from different flavors. Okay, so that's about copyrights. Copyright is for expression of an idea. Trademark is for a symbol. Is for a symbol. Is for a logo. Is for a sound, which creates a connection between the manufacturer and the end user. For example, if you walk into a footwear store, right? If you walk into a footwear store, there are two pairs of shoes which are very, very identical. There are two pairs of shoes which are very identical. One of them does not have a logo on it, right? Another one has a Nike logo on it, right? The pair of shoes which did not have any logo on it would cost you 2,000 rupees. But a shoe with a right mark logo of Nike would cost you 2,400 rupees, right? If you walk into the store and look at these two pairs of shoes, at least 60 to 70% of the buyers would buy what? What would they buy?
Nike maybe.
Nike maybe, right? And even if it is 400 rupees more, why would you buy that? It is not because I don't have, yeah, it is the brand value, right? It is not because I have 400 rupees more, which I can spend. That is not the only reason. The reason could be, oh, this comes from a company known as Nike, and Nike, in my mind, has created an impression that it creates or it manufactures quality products. So I'm ready to invest 400 rupees more. I'm ready to invest 400 rupees more to buy a Nike. When in reality, both of them could be the same, could be identical, right? Right? But you are ready to pay to the brand because it creates a connection between the source and the end use, and the connection is the quality. Brand. What does brand tell you? Brand says quality. And fortunately for big business houses, it also has become a status symbol today, nowadays, right? Well, great. So trademarks, once again, as I said, you don't have to go and register a trademark. For example, you come up with a product and you use that logo for the first time and sell this product. And if you have a receipt of a sale, if you keep it, then that would provide an evidence which could be in your favor, or which could be admitted by the courts in your favor, to say that, okay, here is your trademark. Oh, this person created this trademark. And when it comes to trademark, since I see a lot of comments on trademarks, I would want to bring out one critical. Yeah, there is a duration. I'll talk about protection for design. When it comes to trademark, one thing that you need to remember is some of the trademarks have a TM written next to them in very small size, in a very small font, right? And some of the logos have a circled R close to them, right? Written next to them. What does it signify? So a circled R means that I, as a creator of a trademark, went to the, I approached the trademark office and I disclosed it to the trademark office, and I asked the trademark office to give me a registration, and trademark office would look at your trademark. It would compare it with all the trademarks in its database. And once it finds that your trademark is new, then it will grant you a certificate which says that, oh, this is a registered trademark. And once you have a registered trademark, you can put or you can include a circled R next to your logo. But I did not go to the trademark because it is not mandatory to go to a trademark office to get a registration done. So what I did was I came up with this logo, I affixed it on my first product, and I sold it. And I also have this invoice or bill or whatever you call it, right? It is only a trademark which is not registered yet. I may decide to register it someday, but today, as of now, I have not registered it. So I use a TEM. So that is one thing that we need to bear in mind. And one more thing about, okay, you asked, one of the questions was, what is the duration for a design protection, right? The initial protection for a design is 10 years, which can be extendable by 5 years. So it is 15 years. And when you go to a design office to get your registration done, right, you can definitely go to IP office, India IP office website. The fee structure is provided there. If you are a natural person, if you are an individual, if you are a person from MSME, if you are a person from a big company, the fee is different. And as an applicant, you need to classify your design. There are several design classifications, right? There are several streams. Then you need to look at which stream your design would fall into and mention the design, mention the classification. And one of the standard ways of classifying your design assets is Locarno, which is an agreement between, it is an international agreement, and international agreement provides specific classifications, several classes of classification. Then you can look at this classification. You can also look at India IP office website, and then you can apply for design registration, right? Okay. I receive a question. If TM not registered, what type of problems may arise? Okay. The problem is very similar to a copyright. Let us say I am a very small local manufacturer, right? I manufacture shoes and I put a Nike type symbol on it, and I use the same symbol on it, right? Let us say Nike is not registered yet. Let us say it is not circled or it is just TM. If it is just TM, okay, if Nike drags me to the court, then Nike has responsibility to prove that it is the trademark owner, right? Prima facie, it is not established that Nike is the trademark owner of this right symbol and do it, right? So if in the absence of registering, what Nike has to do is it has to supply all the bills. It has to supply internal documents to show that it came up with this logo first, and it has to show probably the first bill or the, of course, for Nike, these problems would not arise because it is a very well-known brand, but I'm just taking an example, right? Now, because I did not register the trademark, I have the burden of proving that I am the trademark owner, right? This is the first thing. Second thing is, once you come up with a trademark, you have gone to the trademark office, you reached out to the trademark office, and you got a copy of registration. You have a certificate from the trademark office. All you have to do in the court is, my lords, here is the certificate of trademark, which is a prima facie conclusive proof that I am the owner of the trademark. You don't have to spend time or money on establishing the fact that you are the owner, right? Of course, that can be challenged. That is a different issue. But initially, you are prima facie, you are the owner. You have already established it because you have the certificate. So that is the difference. There is one more question. It's 3:45. I did not even touch about trade secrets. Let me also touch about trade secrets. But one thing is, I'm not in a hurry to complete the topics, but I would definitely want to answer as many questions as possible so that
it's going on very fine. I mean, it's quite interactive. Good way to learn.
Thank you very much. And the recent question is whether conceptual models nomenclature for any concept developed by academicians through their research come under IPR. When I was talking about, since you mentioned conceptual models, here is one thing that I would like to tell you. When I talked about patents, I repeatedly and consistently used this terminology. Ideas supported by implementation details. So as long as you can support your concept or an idea by implementation details, and if it is none, NUN, what is none? Novelty, utility, and non-obviousness. As long as it is none, you will get a patent protection, right? So concepts, abstract ideas are not patentable. Ideas supported by implementation details are what is patentable, right? It's a common, it is half truth, right? People say, oh, ideas are protected by patents. It is half truth. But ideas protected by implementation details is what is protected by patents. For example, if you say that I can run my car on H2O, it's a fantastic idea. There is no doubt about it, right? But if you don't provide the implementation details of how you use H2O to run your car, then there is no patent granted on it. Do you see the difference?
Yes, one more thing. Say, for example, I give the implementation detail in the form of maybe an engineering drawing or something like that. Is it enough, or should I also kind of proof of concept or something like that? And
proof of concept, you don't have to provide a working model. You don't have to carry a working model to the patent office. You have to explain all the special tricks. You have to explain all the implementation details in your patent application, which is a written document, right? Your concept can be implemented in 10 different ways. Your concept can be implemented in 10 different ways. And if you know all the 10 different ways, you can describe all the 10 different ways in your patent application. But if you know only 5, or if you know only 1, that is best known method known to the inventor at the time of invention, right, is what needs to be discussed, right? So, okay, next question is whether software implementation is acceptable. Software implementation for what? Yogarajan. Software implementation, definitely, if it is novel, right? If it is new, if it is original, you get a copyright on it. If the software
patents, sir.
Patents? Okay.
Patent, yes, sir.
I'm sorry.
Software implementation for a novel concept, novel idea.
Okay. I'll give you an example. Let us say there are several video compression algorithms, right? Or let me call it as video compression techniques, which have got a patent on it, right? Several video compression techniques are patented already, right? The implementation of such video compression techniques may be done using software methods, software techniques, right? Only thing that the patent offices in the world or around the world are saying is, if you just say software without linking it with the hardware, it is hard to patent, because if you don't link it with a hardware, right? If you don't link it with a hardware, what I mean by that is, in your claim, in your patent application, in your claim, you say, okay, here is a method for video compression running on a processor. If you don't associate it with a hardware component, most of the patent offices would reject your patent application, because if you just say a method for video compression technique and list out all the steps, where are you performing it? If all the steps are performed in my head, are you seeking a patent protection for my head? Probably not, right? So that is why most of the patent offices throughout the world are slowly aligning and coming to a conclusion that, okay, there should be a hardware element tied with the software invention, right? So as long as this combination is none, NUN, it should be patentable. But the implementation of the software, as I said earlier, I will repeat it. The video compression technique implemented using C++ is a copyrightable subject matter. Video compression technique implemented using Java, for example, right, is a copyrightable subject matter. This particular implementation, the way in which the code is arranged, the way in which the code is written, is a copyrightable subject matter. Okay. Section 3K of Indian Patent Act says computer programs per se are not patentable. Per se means as is. If you write it on a piece of paper, the code written on a piece of paper as is may not be patentable. Okay. Now, I have 8 more minutes left. I'll talk about trade secrets. Trade secret is a secret as long as you keep it as a secret. Definition looks funny, but that's what it is. In several countries have recognized a need for a legal framework for protecting trade secrets, right? For example, United States of America has a sui generis or as a specific law for protecting trade secrets. Japan has one, Korea has one, China has one, right? The next question is, does India have one? Not yet, right? And there is a lot of contemplation on whether we want to have a separate trade secret law or not. Is an ongoing discussion, at least for a couple of years, right? When it comes to trade secrets, whatever you disclose to the world can be through patent applications. Once you write a patent application and submit the patent application to your patent office, and the patent office publishes your patent application, and later on, hopefully, the patent application is granted by the patent office, right? Then the life of the patent, life of a patent is 20 years from the date of filing, not from the date of grant, from the date of filing. After 20 years, what will happen? It falls into the public domain. Anybody can use it. Anybody can use it after 20 years. Anybody can use it after 20 years. Okay, so it falls into the public domain. Nobody has to come and seek your permission to grant permission to practice your patent. Beyond 20 years, nobody has to come and seek your permission. Okay, now look at trade secrets. As long as it is a secret, it is a secret. One classic example is the chemical composition of Coca-Cola. Even after 100 years, am I audible? Okay. Even after 100 years, the chemical composition of Coca-Cola is working miracles for that organization. Okay. Somebody at that point in time, 100 years back, when they came up with this chemical composition, it could have been easy for them to decide to go get a patent on it. Let us say if they had gone to the patent office and gotten a patent for the chemical composition, 80 years back it would have fallen into the public domain, right? 80 years back it would have fallen into the public domain. Anybody could have manufactured Coca-Cola using the same chemical composition which was disclosed by Coca-Cola. And for the last 80 years, you can just imagine the erosion of, right? Erosion of the value of the company, right? Market capitalization of the company. There would have been erosion of the market capitalization of the company, right? But at that point in time, somebody decided, oh, okay, wait a minute. Let us not go get a patent on it, because I think this chemical composition may be valuable beyond 20 years as well, right? So they kept it as a secret. Even today it is maintained as a trade secret. Okay. So trade secret is that whatever is maintained as a secret will remain a secret until you maintain it as a secret. Okay.
Say, for example, there is a toothpaste manufacturing company, and that manufacturing company is using tobacco in the toothpaste. Okay. And they have protected their formula of making that particular toothpaste and say that this is my trade secret. Now, obviously, it is likely to create some kind of, effect on the general public, which is in a negative way. So what if in such cases, if someone kind of files a case saying that, your toothpaste may have something, and I want to know how to settle such kind of things.
I mean, see, for wanting to know, you cannot file a IP related case, right? You can file a public interest litigation, but you cannot file a IP related case. Once you say that you are filing a IP related case, it means that your rights are infringed, right? The rights granted under the IP law are infringed. Then only you can go to the court seeking remedy for infringement of IP. Let us say there is a toothpaste manufacturer who is mixing tobacco on it. Definitely he would not have gotten a IP right, even if he had gone to the patent office, and even if this chemical composition or whatever it is, formulation, satisfies the criteria of none. Even if it satisfies the criteria of none, you will not get a patent because it is against the public order, right? Whatever is against the public order will not be granted any rights, irrespective of the genuinity, irrespective of the novelty, irrespective of the inventive step of the issue. I mean, of the invention. IP rights are not granted. Okay. In this particular case, somebody has to buy this toothpaste, get it analyzed by a lab or something like that. Then they have to go down the path of public interest litigation or something like that, which is outside the domain of IP and IP infringement.
Understood.
Yeah. 1 more minute. If you have any one final question, I will be happy to answer. Okay, I don't hear any questions. Okay, when the composition of an item, when the composition of an item is kept secret, is there a need for including under IPR? Okay, here is the okay. Great question. The short answer is, of course, I have a long answer. Since we are running out of time, or we have run out of time, the short answer is, once the trade secret is stolen, right? You, as a trade secret owner, can go to the court of law and allege that somebody stole your trade secret. The very next question the court will ask you is, what is your trade secret? Talk about your trade secret. Once you talk about your trade secret in the court of law, there is no more trade. It is no more a trade secret. Okay. So the dilemma of a trade secret holder is this: if I go to the court and seek protection for my trade secret, the very next question is, I have to disclose my trade secret. Does it make a business sense for me to go to the court and disclose my trade secret? Right? That is one question that needs to be answered. And that is a business decision. Though the remedy is a legal remedy, the decision is a business decision. Right? Once you make the decision, we can bring the legal remedy to it. Okay. The another question is whether the composites come under trade secret. Anything, as long as it is maintained as a secret, as long as you don't tell the world, it can be maintained as trade secret. And one way of maintaining a secret is you can label it as Shiv Nadar's top secret, right? Your institution name's top secret, or your institution name and say, okay, confidential information, restricted access. All these are labels that would classify certain information as trade secrets. And please keep this in mind. If you label a document as confidential information, right, and leave it on the table without locking your chamber, and if you go out and if somebody takes it, you have not put in reasonable efforts to maintain your secret a secret. Once you label it as a trade secret, once you label it as a restrictive secret, you need to keep it under lock and key. And it should be shared only with people who have a need to know. And let us say you have come up with a fantastic invention. You don't want to get patents. You don't apply for designs. You don't apply for copyrights. None of it, right? You want to maintain it as a secret, but you want to share it with some other company, right? Or some other organization. Then there are tools, legal tools known as non-disclosure agreements, which binds the other party, the receiving party, from disclosing the confidential information. So first thing is put an NDA in place even before you talk anything substantial, right? So those are some of the reasonable efforts that the owner of a trade secret should. How to apply for a trade secret? There is no express right provided by the government machinery, government office, so there is no need to apply for a trade secret. You need to maintain it as a trade secret within your own organization or within your own whatever setup or team or whatever it is. There is no process like design, like trademarks, which is to be followed. What if a composition is harmful to people and come to light after some examination, like lead component in noodles? I talked about it. It does not fall under IP rights per se, right? It falls into other legal general matter, which is extremely powerful, right? Public interest litigation is extremely powerful, right? And causing injury, grievous injury to public, is a very, 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 very strong ground. I can tell you an example. On your product literature, right? On the cover, on the packaging, you would have put composition. If the noodles had lead in it, and if you have not disclosed it, then you are cheating, right? Consumer protection rights, absolutely, right? So those are the remedies, but it is outside the IP realm of IP law. Okay, I exceeded my time by 4 minutes, and sincere apologies about that.
No. This is the last session, but I'm so happy you could talk at length. It's so difficult to talk at length and engage the audience at the same time. But I'm so happy They
Thank you so much.
participated so well. Of all the sessions, I think this has the maximum number of strings of questions, and I'm sure they must be having a lot of other doubts. So you can always get back to sir with his email ID if he allows for that.
Yeah, absolutely.
Or else, Dr. Murthy, very special thanks because you have spared your precious time on Sunday. That is very important. A lot of people don't want to spare it. And it was indeed, yeah.
Anytime for awareness of IP in India.
Okay, and I just came to know you are Professor Vishwanath's friend.
Oh,
I just came to know.
We are buddies.
Yeah, he just told me yesterday in the mail that one of my friends is coming for the session. So I said, okay, then you can come and join. He said, oh no, Vinita, I'm very pressed for time. You just leave me. So it's interesting to know. And it was a great learning for me also, because although I am a PhD in IP management, but everything I don't know. And this aspect, practitioners are more oriented towards it. Very fine. Thank you so much.
Thank you so much. Thanks a ton for the opportunity. I really appreciate it.
We'll look forward to connect further if required.
Yeah. Thank you so much. Yeah.
Okay.
Always. Thank you, ma'am.
Thank you.
Bye all. Thanks for your time.